Hello everyone, the topic to be discussed today is the legal basis and the definition of the parties' right to independently draft a contract in CISG. As international trade grows, it is vital to understand and study the contractual provisions under the CISG. Under CISG, this requires a balance between contractual freedom and the legal provisions to ensure contractual rights and promote trade. This research advanced scholarship and guides business practice, promoting the integration of theory and practice. The application of the CISG depends on a number of factors. First, both the party to the contract must be parties to the CISG. Second, the CISG does not apply even to state parties if they exclude its application. Third, the purpose of the contract must be the sale of goods. Finally, the CISG generally applies to the contract between business people and not to a situation where at least one party is a consumer. And then, various legal bases affecting the autonomous drafting of contract terms under CISG. The first is to respect the principle of freedom of contract, allowing the parties to a contract to negotiate and draft contract terms on a voluntary, equal, and legal basis. Second, general principles such as a good faith and contract performance also guide to drafting of contract terms. In addition, international trade practice, customary law and international commercial practice law are also important reference bases. Finally, the provisions of domestic law may also affect the drafting of contract terms on some specific issues. And it is necessary to ensure the legality and the validity of contract terms. Next, we will discuss the legal limits of autonomous drafting of contract clause from these 5 aspects. In the process of independent drafting of contract terms under CISG, the parties to contract need to consider various restrictions. The first is the principle of international public order. The contract terms cannot violate the generally recognized international public order, including but not limited to breach of contract, unfair competition, and fraud. The second is the moral principle. The contract terms must not violate the basic moral principles such as good faith and fair dealing. At the same time, the drafting of contract terms is also limited by the provisions of domestic law and should comply with the provisions of domestic law to ensure the legality and validity of the contract. In addition, the terms of the contract must comply with the provisions of the CISG. Otherwise, validity and enforceability of the contract may be affected. The next is in the process of independent drafting of contract terms under CISG, the consistency of the parties' expressions of intent is crucial. The parties to a contract should abide by the principle of good faith. Ensure that the expression of intent of both parties are true, voluntary, and sufficient, and ensure that the terms of the contract are clear and consistent with the wishes of both parties through clear expression of intent. For consultation and negotiation, in addition, the interpretation of contract terms should be consistent with the true intention of the parties to avoid misleading and fraudulent practice. Under CISG, the information asymmetry of the parties may have a significant impact on the validity of the contract. According to CISG, both parties to a contract should maintain equal status to ensure fairness and effectiveness. Unequal information may result in the invalidation or cancellation of the contract, as a party may be treated unfairly or fail to properly understanding rights and obligations. To ensure effectiveness, the parties have a responsibility to disclose important information and ensure adequate communication and understanding of the information. Under CISG, the principle of contract interpretation is very important. According to the Convention, the interpretation of contract terms should be based on the true intention of the parties, give priority to the literal meaning, and follow the principle of good faith without prejudice to the interest of other parties. The contract shall be regarded as a whole and interpreted in accordance with the purpose of the contract and the commercial common sense. International trade practice can be used as a reference to ensure that contract interpretation conforms to the parties' intentions and business practice. Explicit agreement is very important in international trade contracts. The parties may exclude, modify, or add special terms in explicit language to meet the special needs of both parties. These special provisions shall be interpreted in the light of the true intentions of the parties, and although they may conflict with the provisions of the CISG, shall prevail in the relationship between the parties to the contract. When drafting special provisions, reference can be made to international trade practice or industrial specific practice to ensure that they are in line with the actual situation. The CISG ensures the rights of the parties to the contract in many aspects. According to the Article 8 of the Convention, the right to form a contract is established, and the parties to a contract have the right to decide on their own whether to conclude a contract. In addition, in terms of delivery and the payment of goods, Article 30 of the CISG provides that the buyer of the contract has the right to demand the delivery of goods under the contract, while the seller of the contract has the right to demand payment under the contract as for the quality and the conformity requirements of the goods. Article 35 and 41 of CISG stipulate that the buyer shall have the right to require the goods to meet the quality and the conformity standards stipulated in the contract, while the seller shall have the responsibility to ensure that the goods meet the agreed requirements in terms of applicable law. Article 6 of the CISG provides that the parties to the contract have the right to choose the applicable legal provisions, including the CISG and the domestic law. In addition, Article 79 and 74 of the CISG provide that the parties to the contract shall have the right of exception and compensation in the performance of the contract to deal with the possible breach or loss, and have the right to claim termination of the contract or claim for compensation according to the provisions of Article 74 of the CISG. The establishment of these rights provides protection for the parties to the contract and helps to promote the smooth progress of international trade. According to the Articles 30 and 53 of the CISG, the parties to the contract have a number of obligations under the contract for the international sale of goods. The seller is obligated to deliver the goods to the buyer in accordance with the condition and the time stipulated in the contract. At the same time, the contract buyer is responsible for paying the contract seller in accordance with the terms and time stipulated in the contract. Article 35 of CISG stipulated that the contract sellers must ensure that the goods delivered meeting the quality requirements and the conformity standards agreed in the contract to meet the needs of the contract buyer. In addition, Article 47 of CISG stipulated that the parties to the contract must notify the other parties of any situation concerning the performance of the contract within a reasonable time, especially if they find or should find that it may affect the rights and interests of the other parties. They shall promptly notify the other parties. Article 7, Article 30, and Article 53 of the CISG also obligates the parties to the contract to comply with the provisions of the contract, including the delivery of the goods, payment of goods, and the guarantee of the quality of the goods. Finally, Article 7 of CISG stipulated that the parties to a contract must perform the contract in accordance with the principle of reasonable good faith. That is, they should maintain an honest good faith and cooperative attitude during the performance of the contract so as to promote the effective performance of the contract. The provision of CISG on rights are of great significance in the contract of international sale of goods, which ensure the autonomy and equal status of the contract parties in the process of signing the contract and promotes the conduct of the transaction by clearly stipulating contract terms and guaranteeing the quality of goods. Eric creates a stable, fair, and transparent environment for transnational trade, provides legal protection and norms, reduce the occurrence of contract dispute, and thus makes a positive contribution to sustainable development and prosperity of international trade. The CISG ensure the reliable performance of contract, protective the rights and interests of contract parties, and promotes the prosperity of international trade by clear specifying obligations such as delivery payment and quality assurance. The risk of theft is reduced and the transaction reliability is improved. This provision provide legal protection for the parties, promote international economic cooperation, enhance confidence and momentum in international trade, reduce contract dispute and legal cost, and strengthen international economic cooperation and development. To sum up, CISG balance the rights and obligations of contract parties, promote fair trade, reduce contract risk, maintain contract stability, and promotes the development of international trade. It ensures the fairness and the enforceability of contract transactions. Stipulated the rights and obligations of both parties, reduce risk and uncertainty in the process of performance, establish a stable trade environment, and promote the prosperity of international trade. These are the relevant cases. That's all. Thank you for your watching.